Okay.
Okay, roll call for Senate Revenue Committee. Senator Case,
Excused.
Senator French,
Here.
Senator Ide,
Here.
Senator Pappas,
Excused.
and Chairman McEwen.
Here.
We have 3 present. We have a quorum, Mr. Chairman.
Well, thank you. We'll start with Senate File 68, Government-Owned Lands. And I think we'll start with Department of Revenue, if they would please come up and speak to this.
Mr. Chairman, Brenda Henson, Director of the Department of Revenue, and with me I have Ken Gill, Property Tax Division Administrator. We can go over the bill page by page and what it does. I would seek your guidance. This was a interim committee bill at the time in November. We provided a detailed explanation of what brought us to this spot regarding the Supreme Court decision. Didn't know if you wanted to go over that information again, or if you just want to simply look at the bill and how it looks at creating a task force and defining what is a governmental purpose.
I would kind of like to go through it all again, please.
Okay, all
Just
right,
to refresh our memories. We're
okay,
talking about a few questions we have amongst ourselves even.
okay. Well, Mr. Chairman, we're looking at Senate File 68, government-owned lands. And you may recall, back in November, we had just received a Supreme Court decision. It was State of Wyoming versus the Uinta County Assessor. And that decision came out on October 9th, 2024. The question in that case was specific to state-owned land that was being leased to a truck stop and being utilized as a parking lot. The county assessor, pursuant to statute, had always valued the truck stop, the appurtenances, the structures, personal property, all of that, but not the land that was leased from the state of Wyoming. And in this case, she did issue an assessment for the land. And when that was done, the state of Wyoming, through state lands, appealed that assessment. And that went all the way through to the Supreme Court. And the Supreme Court then issued an opinion related to what is governmental use. And I had provided the case in the information back in November. I did not submit it again for this meeting, but key to that case was the fact that in 1955, the legislature passed a resolution proposing to amend our Constitution to state that government-owned property being used for a governmental purpose was exempt from taxation. Prior to 1955, as long as the government owned it, it was exempt from taxation. So that amendment to our Constitution passed, and it still exists in the Constitution today. And what had happened, though, is since that time, the legislature has not defined the term primarily used for a governmental purpose. What is a governmental purpose? I had mentioned at that time that we've had several interim studies on defining governmental purpose, but a bill has not ever made it across the finish line. So as we looked at this case, and if the Supreme Court found that that land was taxable and it was not being used for a governmental purpose, that was fine. But one of the positions that the state had taken is if the court were to find in that manner, they specifically cited the board leases millions of acres of state land to private entities who conduct commercial businesses on the land. For example, grazing livestock by a private lessee is not a governmental purpose. The same holds true of other activities. The court found that whether such an exemption should be created is a policy question for the legislature, not for this court. That the Supreme Court deemed that there was not any statutory exemption for those state lands that are leased to private sector individuals. So we brought this information to the Joint Interim Revenue Committee, and the work product from that is related to Senate File 68. And it should be noted that that Supreme Court decision was in October of 2024, which meant that all of those lands that are not used for a governmental purpose and are leased out to private parties became taxable in October. Now, the assessment date for property taxation is January 1. So we spoke to the Revenue Committee to state the concern that county assessors have statewide related to needing to value a little over 3.4 million acres of land that is currently being leased by the state of Wyoming to private property owners, and that those lease agreements had no provision for the lessee to be responsible for those taxes. That being said, then State Lands, and the director will speak to this, then went to the governor and requested a supplemental budget request. We were able to provide State Lands with an estimated tax amount for all of the grazing leases. We were able to use GIS technology, download all of the state grazing leases, overlay that with our soil survey information that the Department of Revenue provides to county assessors that is the basis for our agricultural land. And then we utilize the highest, within the agricultural land study that we do on an annual basis, we provide a low and a high based on commodity prices, interest rates, those types of things. We use the highest amount to give State Lands an estimate of what property taxes would be for 2025 based on the grazing leases that existed on January 1, and then the maximum amount per acre. Now, granted, the assessors will be determining what per acre value per class. Just a quick reminder, agricultural land, you have to meet 4 criteria to be valued as agricultural land. And then we look at what's its value based on its ability to produce. And then that is the assessment that goes out. So we made an assumption that all of the grazing leases would be rangeland in that analysis. And then we assumed that all of the lessees were using the land to its capability to produce. We had to make a lot of assumptions because for private property owners, they actually apply by completing an affidavit to show the county assessor that they've met the 4 criteria. We don't have time in 2025 to do that. And so we're just trying to figure out how do we support the county assessors in their effort of valuing 3.4 million acres for 2025. And we can do that if there is not legislation passed during the 2025 session that is backdated to January 1, 2025, exempting those lands. What came out of the interim is the document you have before you, the bill, Senate File 68. And when we look at page 1, basically that just explains, that it is a bill that clarifies taxability of state-owned lands, providing a sunset date, also creating a task force to look at not just state-owned lands, but all government-owned properties and the use and whether it should be deemed as exempt. Turning on to page 2. This particular bill says on line 8, page 2, lands owned by the state of Wyoming are exempt from property taxation regardless of the use of the lands. Nothing in this paragraph shall prevent the taxation of other property, including improvements to the land. If you look at Title 39, it specifically says currently that if the land is leased out, there are certain criteria for state-owned lands that make that land, that property taxable. And so there's nothing in this bill that would override what's in current statute related to that taxability. But it would provide a 2-year window for 2025 and 2026 that there would be an exemption on all land that is owned by the state of Wyoming, excluding these caveats, so that a task force could investigate governmental owned lands and determine what is a governmental, primarily used for a governmental purpose. The remainder of the bill is related to section 3, which looks at how that task force is to be created and when they have to have their report back to the legislature, because this exemption is for a 2-year time period. Now, that being said, county assessors across the state are required to have assessment schedules out by the 4th Monday in April. So that is why time is of the essence to ensure that if there is no exemption that is placed on the books for 2025, that county assessors can include those state lands, state grazing lease lands on the assessment roll. Now, I will tell you that the commercial operators, similar to the case that this Supreme Court decision was based on, county assessors were already valuing the structures and personal property. So what this case basically directed them to do is simply add the land on those properties to the assessment rolls. And they will do that. The state lands director can speak to the different types of leases that they have, not just grazing leases, but they also have special purpose leases. We also know that there are mineral leases that are out there. Now, we are only concerned with the surface of for property taxation. We aren't tracking who owns the mineral lease under the ground, but just the surface. We do know that we have leases that the state has leases where there's multiple leases of the same legal description. You may have a grazing lease and have a mineral lease or a special purpose lease on the same ground. And those are items that we'll need to identify and work with state lands to ensure that we're not double assessing. It is my understanding that state lands on the leases for commercial type properties outside of grazing leases, that the majority of those leases do have a provision within them that say if that land is leased out, that the lessee is then responsible for those taxes, should there be any. But they can, the director can speak to that as well. Mr. Chairman, I think I'll stop there, and I'd be happy to answer any questions. Like I stated, this was information we provided in the November interim meeting, and I believe Senator Case is the only member that wasn't present during that, but Senator Case is very well versed on this subject of governmental owned property, what is primarily used for governmental use, and then the possibility of ensuring that we are being consistent in how we apply those statutes statewide.
Thank you. You did clear up a couple questions I had in my mind with it, and I thought it would be better to have you go through it before I said something I didn't want to say. Thank you. Senator French.
Thank you, Mr. Chairman, Director. So what was I think the money set aside by the governor, correct me, like $3.5 million or something like that?
Mr. Chairman, Senator French, Director from State Lands can speak to that. But I believe it was right at 3 million as an estimate of what the taxes would be on the grazing leases.
So that is bottom line, a new tax for those lessees that they've been paying on, like you say, the structures of whatever shed, whatever the assessor assesses on that. But this is something new to them. So yeah, hopefully he can clarify some of it.
And Mr. Chairman, Senator French, it was our understanding that the current leases for grazing do not have a provision for the lessee to be responsible for those taxes if there were any. So it's my understanding that that is why the State Lands Director was requesting funds so that they can actually pay those taxes.
Okay. All right. Questions?
Senator Ide.
Thank you, Mr. Chairman. Director Hansen, thanks for the good recap of this bill. So in the Ag Committee, we got another similar bill out that was just real short and sweet. This one addresses more of the task force priorities and what they're supposed to do to bring back. I guess I'm a little bit confused on that as far as that task force. I guess it's good to know sort of what's going on out there that you haven't known in the past, but is it fully necessary? I mean, the Ag Bill just kind of gets it back to where it was effectively. If I'm not reading this right, let me tell me what you think. Thank you, Mr. Chair.
Go ahead, Ms. Henson.
Mr. Chairman, Senator Ide. So the bill, Senate File 81, that came out of the Agricultural Committee was amended to specifically, at this point, address grazing land. And it does put a 2-year, I believe, and then a sunset. So the thought process is that the legislature would look at this and take testimony. I failed to mention that historically, county assessors across the state, everyone knew that we could not find, county attorneys have looked at this, we could not find anything in statute that basically defended not assessing lands that were being used by lessee that were owned by the government. So this case just confirmed that. And since it's a Supreme Court decision, I believe that it is important to look further than just the state grazing leases and to look at applying the exemptions for governmental purpose uniformly across the state. Because I'll tell you that county attorneys have been hesitant to take this question to an appeal because the legal presumption is that government-owned property is exempt unless proven otherwise. So that's just the opposite with private property. If a property owner believes his property to be exempt, the legal presumption is that it's taxable until proven exempt. So we find that many assessors are not willing, and they don't have legal counsel that's willing to take these forward. And although it has put county assessors in an interesting situation for 2025 based on this Supreme Court decision, it did answer the question. It basically said, the Supreme Court said the legislature is the only body that can identify what is a governmental purpose and deem a property exempt pursuant to the Constitution and our state statutes. And we just don't have that guidance. And I would, that is the reason that the bill came out of revenue with this other piece to it, because it's not just state lands, it's county-owned lands, city-owned lands. There's a question about federal government. If the federal government has lands that they're leasing out to private parties, should that land be taxable? there you've got another piece of PILT money, and those types of things. So it is very broad when we start looking at governmental exemptions, and that the reasoning for the task force during the interim was that because it is such a broad subject, it would be best to have a task force that is focused on governmental exemptions as opposed to trying to fit it in with the other topics that Revenue Committee or another committee may have. So that I am just basically restating what the discussion was during the November meeting. But that is the difference between the two bills. This bill has a broader perspective of governmental purpose than the bill that came out of agriculture, which is focused on just grazing leases.
Thank you. Please hang around in case we have other questions.
Thank you, Mr. Chairman.
Mr. Chairman,
Senator Case.
I did want to let the committee know that I did file a bill called Government Property Taxation and Sale. It is a bill that's a resurrect of the work of the Revenue Committee in 2020. That was a budget year, and this bill didn't receive the votes to get introduced. But it, excuse me, I'm so sorry. That interim, we had spent a lot of time on the government property issue, and we had actually come up with a bill that specified different types of government property and what would be taxable, what would be considered government property or not. It sort of anticipated the events that happened with respect to the Supreme Court decision. And so that'll be floating around. I would hope we could maybe hold the bill, look at that bill and hold them together, and they're two different approaches. One, we did have a task force, to be honest. We spent most of an interim on it, and it was brutal, but we did it. So that bill's coming. It's going to be, I think it's Senate File 185.
And Mr. Chairman, Senator Case, if the committee is interested in, there was a presentation that I had done back in 2020, and I believe I did it again in 2023 for the interim, but I'd be happy to share that. And it points out some of the complexities and some of the answers, but Senator Case is correct that that bill is the product of interim work that was extensive in 2020.
Senator Ride.
Thank you, Mr. Chairman. One more quick question. You've heard it in both committees going back to 1955, and there was a court case then in 55, or was it just a statute that was changed? Just kind of clear me up on how and why, and are we getting back to where we were prior 55? Is that effectively what we're trying to do? Thank you, Mr. Chairman.
Mr. Chairman, Senator Ide, Mr. Gill has done an extensive amount of research related to 55, and it was a different time period. He has all the articles that were from that time period, and I'd like for him to provide you a little bit of documentation, a little bit of a taste, flavor for where the public's perspective was at that time.
Mr. Chairman, Ken Gill, Administrator, Property Tax Division. I did quite a bit of research. In 1954, the Ways and Means Committee, so now Revenue, the Ways and Means Committee looked to get rid of around 16 exemptions that were currently in the books. One of them was veterans exemption. One of the articles I saw, I think at the time, really, the state of Wyoming was in a particular way where they didn't have a good revenue at that point. They were exempting so many things. And one of the exemptions that they went after was the veterans exemption at that time. And at that time, instead of just getting rid of the veterans exemption, they phased it out. So they gave a lifetime benefit of $800 per veteran. Once that 800 ran out, then they no longer qualified for the exemption. Now, of course, that changed later in 2007, I believe. That changed later to where now it's a lifetime benefit. No longer is there an 800 limit. There, I believe at that time, reading those newspaper articles, all of those exemptions, repealing those exemptions passed at that point in time. And then, of course, the bill went through in 1955, went to the voters in 56, and the voters voted in the governmental purpose piece into the Constitution. So I think at the time, maybe it was a look at the state competing with private entities. I think that was a piece of it. I have a 30-some-odd page report that I'm happy to share with the committee if you'd like to see it, but very good articles from that time period.
And Mr. Chairman, so the focus was broadening the tax base, eliminating exemption, focus on broadening the tax base, just a different way of approaching taxes in general.
I just wanted to make sure as I read the bill and what I thought the bill did, I was close, but not as close as what you brought us to today. Basically 2 years worth of exemptions while a task force figures out the definition of governmental use. Am I correct on that? Thank you, ma'am.
Mr. Chairman, you are correct. It's a broad clarification to ensure that county assessors across the state are interpreting what is a governmental, primarily used for a governmental purpose across the state without litigating. The last thing I think as taxpayers that we all want is for various taxing entities litigating to get to an answer because it costs money.
Senator Ide, or Senator Case.
Mr. Chairman, I'm being called to appropriations. There's a tribal bill up there. I would not support this bill, and I'd be a no vote if it were pushed to a vote, but I would support laying it back and looking at the other bill, because you'll see what you're getting into with House Bill 185. You'll see what the task force, what a big lift it is. And I hope maybe we could look at them together. But it's totally your call, sir. I'd leave a no vote if this bill were to be up for vote. Is that okay?
That is absolutely fine. Thank you, Senator Case.
Good afternoon, Mr. Chairman. My name is Jason Crowder. I'm the interim director for the Office of State Lands and Investments. I appreciate the opportunity to speak to you about the bill, and I think Director Hansen always does a great job explaining this situation and does it much more justice than I ever could, so I'm glad that she always goes first. I'm happy to answer any questions as they relate specifically to state land. I think one of the main comments that she made was this isn't focused just on trust land. It's focused on all governmental lands, and we have a purview of just a little bit of that. But it does go a little bit further than the normal 16s and 36s that we're all accustomed to, and it does go a little bit further than just the grazing leases that we've all talked about. As you're aware, back in 2013, the legislature granted authority to the Board of Land Commissioners over all institutional lands that were not directly utilized for the institutional purpose, meaning anything outside of the state penitentiary that wasn't inside the fence is now under the jurisdiction of the Board of Land Commissioners. Anything at the state hospital, Department of Family Services, everything around the Life Resource Center in that area around the Vets Home in Buffalo are now under the jurisdiction of the Board of Land Commissioners. So if this bill were not to pass, and with the Supreme Court decision, those lands are now taxable because they're not directly utilized for a governmental purpose the way we've always defined it. So it is just a little bit broader than our idea of the 16s and 36s, I guess. One of the things that we need to work through, and we're excited to work through this process if a task force does get nominated, because we don't know what that governmental purpose is. Obviously, we've had a long history of understanding, or an understanding back then of what it could be, which meant revenue generation back to those beneficiaries that are identified within the Constitution and within state statute. Supreme Court has enlightened us differently, that because those are private individuals that are generating that revenue for us, that it's not a governmental purpose and therefore it's taxable. So we're changing our thinking a little bit. But we do have lands, specifically in Teton County, that have no users on them. They are just out there and they're vacant in our definition, but they're highly valuable. So the state of Wyoming in those cases will be responsible, because there's no users, for the tax burden on them. And that's one of the reasons why we did, with the governor, put forward a supplemental budget request for $3 million, as Director Henson mentioned, to try to cover some of those situations where there were no pass-throughs in the lease agreements, and when there's vacant land. So having a definition of governmental purpose and having an understanding of how to handle those properties is something that we look forward to working with this committee or anybody else going forward, if it's a task force, to try to define what that is. One of the other things that I think is important to note is that, as Director Henson mentioned, there are not a lot of leases that have a pass-through to the lessee. Where the pass-throughs do exist is on commercial leases. The one that brought this up, the parking lot for the pilot truck stop, sits on a parcel of land that's owned by the Department of Health that we took jurisdiction over back in 2013 when the legislature made that change. That specific lease was one that was given to us. We didn't negotiate it. The Board of Land Commissioners didn't negotiate it, but it came with a provision that passed that tax on through. Other examples would be wind leases. Those do have provisions that pass the tax on to those lessees. But when we have the variety of other commercial leases, like tank farms, offset well pads for oil and gas that aren't producing state minerals, those types of leases don't have the tax burden passed on to the lessee, and so that remains with the state. And again, all the grazing leases, as she mentioned, also have them stay with the state. So without that pass-through, it is an obligation of the Board of Land Commissioners, the Office of State Lands, to pay whatever is assessed by the county commissioners. I won't go through all of the work that's yet to be done, the uses that are stacked on top of each other, all of those things. Those are things that we'll need to work with the county assessors and with the Department of Revenue on to see what the appropriate way to assess that tax is. But certainly a large lift and something we need to work through over the next year. But the Board of Land Commissioners doesn't have that funding yet. It's only through an appropriation by the legislature will we have that funding. The Office of State Lands and Investments does not have a line item or anywhere in its operational budget where it can absorb this type of tax increase. So it does need to ask for an appropriation if there's not an exemption, or it needs to pass that on to the lessee. So the Board of Land Commissioners did ask for a set of rules, and I provided that to them in December to look at passing that cost on to the lessee, if it's the grazing lessee or commercial lessee, but any lessee that doesn't have that pass-through already there, it asked for that set of rules. During that meeting, it also tabled the discussion until the legislature did its work to see if there was going to be an exemption passed or not, and what that pass-through could or should look like. So it hasn't taken any action, but there's no money to pay it right now, and without an appropriation, there still wouldn't be one, and without an exemption, there's still an obligation. So the Board of Land Commissioners is very seriously looking at where should that be paid? Should it be borne on the back of the lessee, or should it be something that the state takes on by itself? So, Mr. Chairman, I think those were all the questions I heard while Director Henson was up here, and I'm happy to answer any others that you might have.
Senator Pappas.
Thank you, Mr. Crowder. To your point about the lands being vacant, could we just simply put a provision on there that if it's not income producing, it would be exempt? Would that be simple enough?
Mr. Chairman, Senator Pappas, that would encompass the small bit that is vacant lands. And I should have mentioned this, 98% of our lands have a lease on it. Only 2% don't. And unfortunately, that 2% happens to sit in some of the highest valued property in the state. But it's certainly a policy call for the legislature to make that exemption if that's what you'd like to do. But it would be saving the tax obligation on 2% of the land we manage.
Senator French?
Thank you, Mr. Chairman. Jason, you might have mentioned it, and apologies if you did, but if you have a grazing or commercial or any of these lease, and this bill doesn't pass, doesn't make it, are they grandfathered in?
Mr. Chairman, Senator French, to a certain extent, those leases will renew at some point in time, and that's one of the asks we made of the Board of Land Commissioners, is to give us direction that every time a lease renewed, or if it was extended for any reason, if there was some reason that we could open up the agreement, the document between the lessor and the lessee, that we would be directed to insert that provision. That's one thing that they're looking at. So I would say, yes, they are grandfathered only because we can't insert a provision like this if it's not already there until there's a break in the lease.
Thank you.
Senator Wright?
Thank you, Mr. Chairman, Director. I'm trying to get my head around the pass-throughs, and, you know, the state owns the land. If you have, like if you own a piece of private property and you disagree with the value that you're getting, you protest that to the State Board of Equalization or the County Board of Equalization. And it gets confusing for me when the state owns the land and the State Board of Equalization is your only outlet to say, you know, taxes are too high on here, and then where does the lessee come in if he thinks he's getting you know, charged too much for the property taxes that are getting passed through? And then after that, can you explain how that process works currently with pass-throughs on what you guys do with state-owned land? So thank you, Mr. Chairman.
Mr. Chairman, Senator Ide, yes, that will be a talking point as we go forward in the planning process if there's not an exemption, because that's brand new dirt for us to plow. We'd have no idea how any of that works yet, and we need to come up with a process for that. But how it works now is exactly what brought us here today. So we had a county assessor in Uena County assess a piece of ground as eligible for taxation, and we disagreed. So we went to the county commissioners. The county commissioners actually agreed with us. The county assessor appealed that to the county board of control. The county board of control agreed with her, and then we appealed it to the state board of equalization, not control, I apologize. And the state board of equalization agreed with her as well, and so we took it to the district court and then Supreme Court. And so that's how we got to where we are today, and that's how the process works.
Go ahead, Senator Wright.
Thank you, Mr. Chairman. Just a quick follow-up. How many numbers of situations do you have where you're getting a bill from the county assessor right now? Do you have more than just what happened in Uena County? Thank you, Mr. Chairman.
Mr. Chairman, Senator Ide, great question. So to my knowledge, we've had 3. The other 2, besides the one in Uena County, we were able to talk with that county assessor, and I don't know if they agreed with us that state lands weren't taxable, but they ended up not pursuing the assessment.
Well, thank you for your testimony.
Sure.
Please stick around if you would. Do we have any other testimony?
Thank you, Mr. Chairman. Jim McGagnon with the Wyoming Stockgrowers Association, and we certainly feel there's a need for this legislation at this point in time in light of what the Supreme Court decision was. There are just a lot of factors that need to be worked out here. Certainly would agree that it's a burden on the state if they have to pay all of these taxes, but for just passing them on to grazing lessees, one issue that arose that previous speaker addressed is that grazing leases are for 10 years. So if I renewed my lease in 2024, it wasn't subject to that tax. If I happen to be a person who has to renew it in 2025, if we didn't do something like this, then it would be subject to that tax. So it would create a real inequity there unless the legislature were able to work out some system whereby we spread that equity. The other thing that happens is we certainly have confidence in our county assessors that they can set the ag productive value of the land, what the land produces. But you have to look beyond that to the landowners or lessee's ability to use that land. And one example I can think of that certainly doesn't apply everywhere, would apply on a lot of these lands. The Board of Land Commissioners in the early 1980s opened up all state lands that have legal access to public recreation. And in some areas, that public recreation today is very heavy, and that's interfering with the extent to which the grazing lessee can utilize the available forage. So if you're looking at an equitable basis, the assessor is going to say, here's a piece of private land, here's state land right adjacent to it. We value those equally, which from their perspective is correct. But as the agricultural producer, the value I'm able to derive from that lease may vary significantly from my private land where I'm totally in control to state land where I have limited control. Another factor was brought up is that there may be more than one activity on the state land. It may have grazing on it, but it may have some facilities for mineral production or something located on there as well, and all that would have to be taken into account. So what we're really saying is that this needs some careful study, such as is proposed with the task force that's contained in this legislation. And I think that as that goes forward, I mean, not an easy remedy, but one that should at least be on the table for consideration would be perhaps we need to go back and propose a constitutional amendment to correct what was done in 1956 so that lands that are owned by the state of Wyoming or by state and local governments would no longer be taxable. That certainly is not the only answer, but it's something that should be on the table for discussion. So for all of those reasons, the complexities involved and the inequities that can be involved, we would encourage that this bill move forward. I have some minor recollection of the bill that Senator Case brought a number of years ago. I recall looking at it back then, but I'm not familiar enough with it today, and it hasn't been posted yet to really say whether that would be a good substitute for this. So we would encourage it. At this point, you move forward with this bill, and if it turns out we have something else that resolves this, then there's always the opportunity to not go further with it. With that, Mr. Chairman, I'd be happy to take any questions.
Senator Ide.
Thank you, Mr. Chairman. Just real quick, we've got the ag one that we got out of committee too. What's your opinion on the two compared to each other? Do you have one? Thank you, Mr. Chairman.
Mr. Chairman, Senator Ide, from a strict ag perspective, I think either one of these bills could meet our need, but honestly feel that this issue needs to be looked at a little more broadly than just the ag component. And the one advantage of this bill is that it provides that opportunity to look at ag, but to look at some of the other uses and how the uses complement or conflict with each other as well. So I think this would be probably the preferred bill to move forward at this point in time.
Well, thank you for your testimony.
Thank you, Mr. Chairman.
We have anybody else? We have anybody on Zoom?
Not for this bill, Mr. Chairman.
We ready to close public comment? Well, with that, we'll close public comment. What's your pleasure? It's been moved by Senator French and seconded by Senator Ide. Let's work the bill. Really don't get into much changes until line 8 on page 2. Any suggested changes on page 2? Going to page 3. Start getting into the task force. Changes? Page 4. Page 5.
Mr. Chairman. This, on the top of page 5, the $20,000 appropriation from the general fund to the governor's office. I'm not sure where that number came from, I guess, but is there any comments on? And then in line 12, the 45,000, is that gonna accomplish what we need to? Apparently somebody did a little study on that. You did, yeah, go ahead.
Mr. Chairman,
Senator Pappas.
typically those have been standard numbers that we've been using for task forces. I think that's just from past experience, what they need to fund it. So I don't know that a whole lot of effort was put into calculate what it's gonna take, but these are just placeholders. You know, if they don't use it, they don't use it.
Okay. Page 6.
So my only question is, this, if we did get this passed through, oh, I'm sorry. Thank you, Mr. Chairman. I assume from all of the discussion that this backs everything up to January 1st of 2025 and gets us a little stay on this thing until this task force gets done, so we don't have to start worrying about passing through property taxes to everybody. Is that correct? Yeah.
That is my understanding.
Thank you, Mr. Chairman.
Senator Pappas.
Yeah, so for what it's worth, my 2 cents worth on this bill, you know, I'm a little bit uncomfortable with it. However, I understand where we want to go. I'm not sure we're there, but I think I'm kind of in the same position as Senator Case was. However, I'm going to vote for this bill only because I think that we really need to take a deeper dive, and this gives us the task force to do it. And since it's already got the repeal date of January 1, 27, you know, it gives me a little bit more comfort. But I really think that there's some problems with it, but we need to, but I'm willing to hammer it out in a task force.
I would agree. Senator Ide.
Thank you, Mr. Chairman. Yeah, and as long as we have the Department of Revenue in here, it would be helpful, I think, if we had some of that discussion on broadening the tax base. Ways and Means Committee back in 55, just for a little backdrop on the discussion of why effectively that's what caused this issue to get in the first place. Thank you, Mr. Chairman.
Well, I think the report Mr. Gill has will kind of answer most of those questions, won't it? I'll talk to you afterwards, see if we can get copies of it. Anything further? You please call the roll, Donna?
This is a roll call vote on Senate File 68, government-owned lands. Senator Case?
No.
Senator French?
Aye.
Was that an aye? Senator?
Aye.
Senator Ide?
Aye.
Senator Pappas?
Aye.
Chairman McEwen?
Aye.
We have 4 aye, Mr. Chairman.
Well, that passes the Revenue Committee. Next bill we'll look at is Senate File 85. Sponsored by Senator Bob Ide.
Might as well go up on the, so I can face the army here. Read it.
Go ahead, Senator Ide.
Thank you, Mr. Chairman. Members, Senator French, Senator Pappas, that's all we have left up there. This is kind of a neat little bill here that has some teeth in it to enforce constitutional provisions. And I'll just go ahead and start out giving you a little short snapshot of this thing. I think I can read my notes here that covers the whole bill and save everybody some time. So this bill, Senate File 85, Constitutional Enforcement of Localities, is a real straightforward bill that will implement a program to prohibit Wyoming's counties, cities, and towns from violating our state laws or constitution. Just a few bullet points on here, what the bill does. At the request of a legislator, the Attorney General shall investigate an ordinance or regulation of a city, town, of a county, city, or town that may violate state law or the Wyoming Constitution. Within 30 days of the request, the Attorney General shall make a written report of the findings. If the AG concludes there is indeed a violation, it shall provide notice to this county, city, or town and allow 30 days for resolution of the violation. If the offending city, county, or town fails to resolve the violation within 30 days, the state treasurer can withhold shared monies in the general fund. So that's the teeth part of this. It basically, has an enforcement here. If you have a grievance of something that's a violation of a statute or of the state constitution, and they just sort of, set you off and say, we'll look into that, and you never hear back from anybody. This puts a little teeth in the bill here to, if they don't do something, they suffer some consequences. So, and then upon resolution of the violation, the treasurer shall restore the shared revenues back to the county, city, or town. So there's some good examples. This is sort of patterned after a bill in Arizona that's worked real well, and I can show you more information. But the big one that sticks out to me there is they had a hiking trail in Arizona that they had a city ordinance of no carrying of firearms. And somebody flagged that. They went to their state legislator, just said, hey, our state US Constitution, they can't legally do what they're trying to do there on these hiking trails. So that legislator goes to the AG, they look into it and said, yeah, you're right. They have the right to bear arms here. And they give notice to the city, town, or county and saying, you got to take your signs down and that ordinance is unconstitutional. So unless you deal with that and take care of that situation, your funds will be held, sales tax, basically revenue, until you get that taken care of. So that's the good part of this bill. Some examples in Wyoming, citywide mask mandates were implemented during COVID, and that's unconstitutional. They just across the board, the merchants, the restaurants, somebody could go to their state legislator same way and just say, I thought, the Declaration of Rights in the US or in the Wyoming Constitution says we have the right to make our own healthcare decisions, and you can't force that on the people and the private entities that are there. So that's another case right there. I think there was one in another town here. I guess I should leave their names out, but they had a citywide mandate on no plastic grocery sacks to everybody. And there again, it's unconstitutional to do that. So somebody could go to there again, your state legislature, they could go to the AG and just say, you're violating that. You can't make that mandate across the board, you know, unilaterally. So that's the crux of the bill. I think it's a good, simple bill. It's worked well in Arizona. They don't have a whole lot of cases down there, but every one of them essentially has been resolved. And I think it's a good way to enforce the Constitution and the laws of our state to overreach of counties, cities, and towns. So I'll leave that for questions.
Questions of the sponsor? Well, thank you, Senator Ide.
Okay.
Can I ask one?
Sure.
Yes, Senator Case.
Mr. Chairman, Senator Ide, when you mentioned something like the plastic bags, just for example, or another policy that a Wyoming municipality might have, and then you said that's unconstitutional. Tell me how you can determine that it's unconstitutional or how you do that. And I'm not trying to be argumentative, that's a pretty black and white statement you made, and I'm trying to figure it out.
Mr. Chairman, Senator Case, great question. You stepped in a little bit later. I sort of went over that, but I'm happy to.
apologize.
I'm happy to cover that. So essentially, the way the bill works is somebody goes to their legislator in their community, their representative, their senator, and just saying, you know, they've got an ordinance. I used an example of Arizona. It's patterned after a bill that they use down there. And they had an ordinance on a hiking trail of no firearms. And, you know, a person said, hey, this is, you know, the right to bear arms. I thought we could have that everywhere. And so they go to their representative and saying, I think we got a problem here with what they're doing. So that legislator goes to the attorney general. And they have, I think the bill says let me read it here. Let's see, the attorney general shall, hold on one second here. So yeah, they take it to the attorney general, and the attorney general has 30 days to investigate whether that's an actual violation of the Wyoming Constitution or a state law. And they can come back with a yay or a nay that, you know, you're right, and you've got to eliminate that ordinance. And if they don't, that's where the teeth come into the bill is, if they don't, the state has the right to withhold their revenue share from sales taxes until they comply with that particular decision by the attorney general.
And so, Mr. Chairman, in that case, the attorney general is making a determination, but they're just another lawyer, you know, they have an opinion, and it only, for that to actually be decided, it wouldn't have to go to court. I mean, couldn't a court say this is unconstitutional, fix it? I don't see how the attorney general, they may opine on that they think it's unconstitutional, but until it's happens in a court order, it's just their opinion, and they're really just another lawyer.
Yeah, the top lawyer in the state essentially to determine whether or not there's a case there or not. And I presume the county at that point could say, we disagree with you, but I think a lot of these are going to be probably, I don't know. That's a good question there. Who else would determine that? Would you file a lawsuit to determine that? And then all of the lawyers everybody, the state and the individual space, or the county, city or town spends the money on their lawyers.
Mr. Chairman.
Go ahead.
Oh, yeah.
So I think that's kind of the only way, because even if our attorney general were to pronounce that this town's ban of plastic bags is unconstitutional, and therefore we're going to not have money, well, it doesn't eliminate the ability for the town that we're talking about to go to court and say, we think it's constitutional, And we think now that the state has unlawfully withheld our money. So it seems like you're gonna end up in court anyway if you, to me, that's what it seems like it leads to me. I don't think it short circuits any court actions. And honestly, attorney generals, they're just another lawyer. Thank you, Mr. Chairman.
Mr. Chairman, Senator Case, yeah, that's good for discussion. I think that this gives individuals the opportunity to hold their local authorities accountable as well, too, instead of them having to file their own lawsuit. That's effectively what would have to happen, because, the municipality, whoever it is, they say, sue us then effectively. And this is a good way for an individual to hold their municipalities accountable. Thank you, Mr. Chairman. Senator Case.
Some of that's getting on discussion. I'll wait. Thanks.
Senator French.
Thank you, Mr. Chairman. Senator Ide. The first part of it is somebody goes to the Attorney General with a complaint, whatever. He's got 30 days. He makes his decision, or she makes their decision, and then they notify the city, town, or county, and they've got 30 days to rectify the matter, or you start losing funds at that point. So when the Attorney General is notified, there's no heads up to the cities, towns, and counties, kind of give them like an extra grace period. Hey, I'm checking into a complaint on you. And they have to wait until he comes or she says, hey, I've found out this, and you have 30 days to correct it. So there's really no, I guess, extra notification or anything.
No, I think the way the bill reads, if an individual sees an issue with his municipality, whoever it may be, if he knows this, that we have a statute, he can go to his state legislator and just say, I think that the city and town or county is in violation of what I think is my right to bear arms on this hiking trail. And, but no, it's a good question. The way the bill reads right now is the Attorney General notifies them, and then they have the 30 days to do it. And it's probably the best place maybe to start, in my opinion, is maybe having the authorities saying, hey, we've got a complaint here, and we need to address that now. And you've got some time to get your people to look at it and get back with us.
Thank you.
Thank you, Mr. French. Senator French.
Thank you, Senator Ide. Open it up for public comment. Anybody? Okay, state your name.
Thank you, Mr. Chairman. Joey Correnti. I am the Executive Director of Rural Wyoming Matters. We are a educational, informational, and advocacy group that operates throughout rural Wyoming. Bill is an old friend of the committee and the chamber, and I eventually would like to see it only exist in the books behind your desks. But I do see some issues, and I'm going to sit kind of asymmetrical arguments. But the dead-on arguments is I agree with some of the questions I've heard. We're talking about upholding the Constitution in what I see rubbing up against a violation of Article 1, Section 7, the Attorney General having the absolute and arbitrary power to say, do this, change this, or we're taking your money. There's no appeals process. You only have 30 days to comply is the way I read it. But I love the spirit of the bill. So maybe, I don't know if Chancery Court would be more appropriate because it's not really a criminal, or just engaging in the due process that we would expect or demand through our Constitution if any of us would be facing violating the law or the Constitution. Because this really is a anti-rules for thee but not for me bill, and we can't I wouldn't be comfortable instituting rules for thee, but not for me. So I say we stick to the Constitution. We avoid that absolute arbitrary power. I live in the same town that the current Attorney General comes from. And I would agree that that opinion, depending on where it is and what it is, could be skewed by nostalgia, sentimentality, depending on what municipality, what county it is. And I would hate for that to violate the due process rights of an individual. So I would have to hate for it to violate the due process rights of a political subdivision of the state. That being said, the kind of asymmetrical view is I love the accountability part of this, not just from the top down, but it gives the people something tangible to do the accountability part from the bottom up. Hey, we elected you. The law says this, the Constitution says this, and we have these expectations of you. And 4 times in the last 2 years, you have caused our municipality, our county, to not receive the regular operational funds because you want to play some game or you want to be ignorant or whatever they feel it is. And eventually that bill comes due. Now, it may come due in the form of your funds from the shared funds from the state are not coming down, but not all bills are written on invoices. So this may turn into a situation where that bill comes due on a ballot. So, Mr. Chairman, committee, if the language could be addressed about enforceability and due process, I'd be 100% behind it. If it can't, I'll continue to support it in spirit, but in my mind, 2 wrongs don't make a right, and that Article 1, Section 7 concern of mine doesn't go away real easy. And with that, Mr. Chairman, I'll stand for any questions.
Questions? Senator Wright.
Thank you, Mr. Chairman. Thank you, Mr. Corrente. Good comments. You know, as you mentioned, you know, cities, towns, counties are subdivisions of the state, essentially. And, you know, the crux of the bill, as you eloquently said, is to give the individual an opportunity to push back. And that is the spirit of the bill. You know, how we could amend the language to, for more due process, as you referred to. I'm not sure. I'm willing to look at what you might recommend there, but I think that we need a process for people so their local municipalities don't thumb their nose at them and just say, sorry, that's the ordinance, and good luck. Yeah, thank you, Mr. Chairman.
Mr. Chairman, Senator Ide, I would agree. And the process, as I'm looking at it, it's not problematic. It's the authority where we're pointing specifically to the Attorney General. I will refer to my time in the military. If you want to get someone's attention and you want to adjust behaviors, you tap their time and you tap their money. And I believe our legal process, now it's not a timely process, I understand, but I believe that would be the correct process. And I think a lot of these situations would be, well, now you have to go to court. Okay, well, we'd rather not do that. So let's take the 30 days and fix the problem. They can give them the opportunity to make the better decision. Again, like I said, I'm all about the accountability piece. I'm a little concerned that we are not only doing what I'm interpreting as a violation of Article 1, Section 7, but we're putting it through a non-elected official. If this is a posture that we're just looking at, okay, they're strictly political subdivisions of the state and they are under the control of the state, then let's not do legislation. Let's get a policy from the chief executive and say, hey, it's internal, it's in-house, you control it from the top to the bottom, it's all within the state. Make it your problem. I want to see this succeed. I want to see it happen. And I'm willing to make a good thing less ugly. But if it's gonna continue to tickle my, inner ear hairs about violating the Constitution itself while setting a process for holding people accountable or municipalities and counties accountable for violating the Constitution, I don't know if I can sail on that ship. So if we can work it, we can fix it. But I think it's really not the process. I think it's laid out well. It's the authority and who is going to be engaging in that process that brings the concern.
Well, thank you for your testimony.
Afternoon, Mr. Chairman. My name's Dawn Williams. I'm the Deputy State Treasurer. I'm joined here by Katie Smith, my Chief Financial Officer, to keep me straight. Our concern with the bill is just procedurally. On page 7 is the first language that talks about the withholding of funds from a community for noncompliance with whatever violation has occurred. Talks about how the funds shall be withheld, no problem, under this shall be withheld in the general fund and shall revert to the general fund at the end. And I'm on pages 12, or lines 12 and 13 on page 7. Shall revert to the general fund at the end of the fiscal biennium. Our concern with that is that should the entity be able to rectify their situation after the end of the biennium, with what funds would we then, what funds would we return to them? They would have reverted to the general fund. We would have no funds nor appropriation with which to return funds to that entity. And that occurs in both sections, again, on page 9, line 19, where it talks about the shall revert language. So our suggestion would be that you modify that language that they shall not revert and be retained for the purposes of returning them to the local government should they rectify their violation. That's simply our comments. Thank you.
Questions? Senator Wright.
Thank you, Mr. Chairman. Could you, if we work this bill and get that, your preferred language on there, so can kind of track that in a little better?
Sure, Mr. Chairman. Thank you,
Mr. Chairman.
Senator Wright. I'll work with your secretary. That's suitable, acceptable.
More than suitable.
Okay, thank you.
Any other public comment?
Mr. Chairman, we have a number of people that registered online to testify. At least one has their hand up. Oh, they just put their hand down. Now, oh, it's up again. I'm going to admit Max Mickelson.
Okay.
There we go. Good afternoon, Mr. Chairman and committee. My name is Max Mickelson, and I am the mayor in Rock Springs, Wyoming. As I'm sure you are aware, we are a community where this very issue was raised. And as it turns out, the county attorneys and courts were able to resolve the question of whether or not there was impropriety done by the mayor, all on their own without legislative intervention. I'm very strongly opposed to this bill. I think it is really troubling if we're doing this. I would certainly encourage you all to consider including your body in this process. We, all of us, serve our constituents and have mechanisms in place if there is malfeasance or fraud or a violation of the state or federal constitutions to address those issues without an additional mechanism. And so I just wanted to be very brief because I know you all are busy, and say that this is not a bill that I can support, nor is it a bill that I think recognizes the separation of powers and duties within our state. And with that, if you have any questions, I'm certainly happy to elaborate.
Questions? Senator French.
Thank you, Mr. Chairman, sir. Well, this shouldn't be an issue if you're handling any issue in your town or county. Nothing would come from the Attorney General, would it?
Mr. Chairman, Senator French, no, it should not be an issue, which raises the question of why we're proposing the bill from my perspective. And if there is an issue, the mechanisms already exist within our statutes to address it. So I'm not clear on the necessity of this bill in general.
Well, thank you for your testimony.
Certainly, and thank you, gentlemen, for your work.
I have two more individuals. I'm admitting Matt Murdoch.
Thank you. My name is Matt Murrock. I am also the mayor of Pinedale, Wyoming, as well as a board member of the Wyoming Association of Municipalities, which many of you know represents the 99 towns and cities within the state of Wyoming, and is committed to proposing and educating our cities and maintaining a good, transparent government. I am speaking today, Mr. Chairman, in opposition of SF 85. I think there's several issues that have come across my attention that draw concern to it. And I'd like to mention them. Then probably you and your staff can look into it to see if there's legitimate concerns. But we do feel that this is kind of a violation of the separation of powers. Wyoming Constitution Article 2, Section 1 establishes that separation of powers between the legislative, executive, and judicial branches. And it seems that this bill does infringe on this principle by granting legislative enforcement authority through the attorney generals. My second point is I do know that while legislature can ask for the attorney general to review certain things, this particular item actually gives it beyond an opinion, but moves into punitive actions, withholding funds and et cetera, without a judicial review, which seems also kind of a shortcut on due process. Additionally, we think this could be a violation, or I've seen a violation of Article 3, Section 27, which prohibits special laws. It could be targets municipalities by a perceived violation until it's proved. And so the bill does actually create a mechanism for selective enforcement, which resembles a special law, which I think would be inappropriate. And finally, there is quite a bit of existing accountability that already are in place, as Mayor Mickelson spoke out. I know the town of Pinedale, for example, has multiple audits. We have an audit every year. We are actually reviewed. And one of the things that is extremely important is that we obviously have meetings on a regular basis that public or any other people can speak out of and make reports. So I am concerned that this bill does seem to cross certain lines. I completely understand the need for judicial review and other items, but there are mechanisms within this bill that I think violate some of our constitutional rights as cities and towns. And so I would respectfully ask you to vote against this bill. And if you have any questions, I'm prepared to answer what I can.
Any questions? Senator Case.
Thank you very, very much. I think I agree completely with your testimony, but I don't quite agree with the special laws issue that you brought up. I looked at that and I think that whole section's about passing a general law that we couldn't pass a special law, and a law that applies to all cities or all municipalities or all local governments is not a special law. It's still a general law. So I don't think that one flies, but I do think the separation of powers, it's as big as a elephant in this room, actually. And so I think you're right on that. Thank you.
Mr. Chairman, if I may. Mr. Chairman, Senator Case, thank you for your comment. The way I looked at, especially on Article 3, Section 27, is that it actually prohibits laws regulating county, city, or township affairs. So the way this bill is structured is actually only targeting cities or municipalities, and it doesn't broaden it to the over thing. So you're now actually narrowing it down by specifically looking at towns. I think that was kind of more my focus, but I think the elephant in the room is the obvious one, and I appreciate you noticing it as well. So thank you.
Mr. Chairman, can I address that?
Yes, go ahead.
So it's Article 3, Section 27, special and local laws prohibited. And that is just this huge list, but it starts out by saying the legislature shall not pass local or special laws in any of the following enumerated cases. That is to say, and then the first one is for granting a divorce. I think that's a great example. Legislature can't pass a law that says, you and you're now divorced. We can't do that. We have to do it by general law. And so if you go through that, there are many, many things, but it gets down, it's towards the end. Creating offices or prescribing the powers or duties of offices in counties, cities, townships, or school districts. So I think what that's referring to is a special law that says the city of Lander shall do this, as opposed to a special law or a general law that says all municipalities shall do this. I think that's the fine point. I'm sure it's been litigated. There was a university law professor. His name was Rudolph. He wrote a book called Local Government Law. I've got a copy of it. I'm sure that's been addressed in a lot of places, but that's my take on that. We still have the elephant dancing around in this room. Thank you.
Thank you, Mr. Chairman. Thank you, Senator Case.
Any other questions? Thank you for your testimony.
Thank you. Thank you for your service.
Mr. Chairman, just for fun, the last thing is a law authorizing the adoption or legitimation of children. We can't do that. Particular children. We can pass a law about adoption, but not that you will adopt that me as a child.
We don't have to worry about that one. Okay. We have anybody else, Donna?
We do. We have Dominic Wolf. Oh, but Mr. Wolf declined to come in and testify. And we have one more. Oops, let me try Mr. Wolf again because he still has his hand up. And we also have a Sean Dow. I just admitted Sean Dow.
Mr. Chairman, can you hear me now?
I can. Can you hear me?
I can, sir. I'm Sean Dow from Arizona. I've been familiar with this law here in Arizona since 2016. I think I can clear up some of the misconceptions about what's happening here. Once a complete form is submitted by a legislator, a request is deemed received by the Attorney General's office. There's a 30-day period for the office to complete its investigation and for the Attorney General to issue a report concluding whether the action that is the subject of the request violates, may violate, or does violate state law. The towns and cities and most of the time where this happens, and it happens about 30 to 50 times per year, where a city or a town passes a state ordinance and the citizens complain to their legislators that it's illegal. The legislator then submits the formal request on the form to the AG, and the AG opens its investigation, and it's all done online. You can see this online now. If I'm able to share my screen, I can show you. But the entire process is there. Normally what happens is the AG sends the letter saying, here's a complaint. We find that it does violate state law. 90% of the times, the cities repeal the ordinances when that happens, and everything goes back kosher. When it does go to a fight, it usually goes all the way to the Arizona Supreme Court and they issue their ruling. So every town, city has the opportunity and the due process to go to court and fight it. It's just that it doesn't very often happen. I can think of twice in Arizona where it went to the Arizona Supreme Court. Everything is posted online through the Arizona Attorney General's office on every step of the process so that everybody can see what's happened. It's open and it's transparent. Basically, what this law does is it gives you, the elected representatives, the power to force the highest law enforcement person in the land, your state attorney general, to determine immediately, without forcing the public to sue their town and go to court and go through all the process to prove that they're violating the law. It's simply just an investigation whether or not the law is being violated. If it is, the towns and cities are given the opportunity to repeal the ordinance, and 90% of the time, that's exactly what happens. If you go to ag.gov/complaints, you can see all 32 complaints that were filed with the attorney generals in Arizona, along with the outcome all the way down. And most of the time, the cities repeal their ordinances that they were found to be illegal. I'd be happy to answer any questions or clear up any other questions you guys have.
I actually do have a question.
Yes, Mr. Chairman.
So it's almost like if you take a criminal complaint to a county attorney and the county attorney determines whether or not to prosecute.
Well, it's not that they're determined. They have to open an investigation to determine whether or not the city, town, or municipality has violated state law. There are times on occasion you can see on here that they see disposition closed, whether or not Fountain Hills Town Council is in violation of 9-235 and appointing a vacant seat. Disposition closed, the letter requesting the investigation, they found it was not in violation, disposition closed. But if you scroll down to the next one, you can see that Yuma town did violate state law by contracting bidding with unlicensed contractors. And so they were sent a letter requesting the investigation. The Yuma responded to it and they fixed it. And you can see these kind of things happen here in throughout the state. It happens about 30 to 50 times a year. So it's not like these towns and municipalities are the halo wearing angels who never do anything wrong. They need to have these things fixed, and we can have this resolved without wasting taxpayer dollars at the municipal level and at the state level. If they can just get a letter from the attorney general saying we find that our investigation, you are in violation of Constitution or state law. What are you going to do about this? And they say, well, we've repealed the ordinance. Well, that's a cheap fix for the taxpayer, and we don't have to go through courts.
I'd like to finish my question, please.
Yes, sir.
Okay, so, and I talk slow. I'm sorry about that.
I'm sorry, sir. I talk fast.
So, you put in the complaint and then the AG looks at it kind of like a prosecuting attorney. They investigate it and they issue an opinion, or in the prosecuting attorney's case, decide whether to follow through with charges or not. At that point in time, my question is it over? If the town or municipality or whoever we're dealing with decides they're in disagreement, do you see a need for language in this bill to stop the process of taking funds until it is solved at a higher level? Thank you.
Oh, I understand your question, sir, now. No, there's no need to add extra language. The next step is the actions that the Attorney General would normally take in taking them and suing them in state superior court. The normal actions that would happen after that investigation, giving the cities to rectify it first. If they don't rectify it, it would go through the courts, yes. regardless of the language that is in this bill now.
Thank you. Any other questions? Well, I appreciate your testimony. Thank you for stopping by Revenue. Do we have anybody else that wants to testify?
Yes, I just admitted Dominic Wolf.
Donna, do we have another one online?
This is the last person who registered to testify. I do see that Matt Murdock raised his hand again. I don't know if you want to take more than one testimony from the same person.
We will if he's quick.
Okay, I'll admit him after Dominic.
Can everybody hear me?
Yes.
Mr. Chairman and members of the committee, my name's Dominic Wolf. I'm the mayor of the town of Superior. I just have a couple points real quick. I'm here to speak in opposition of Senate File 85. I believe this bill allow one or more members of the Wyoming legislature to initiate an investigation in a local elected official who they believe has violated state law of the Wyoming Constitution. I believe this bill is totally unnecessary and is an overreach of the state authority. There are already laws in place and local prosecutors are available to investigate and prosecute any illegal activities by the local government officials. I believe this bill violates the separation of powers set forth in the Wyoming Constitution. As noted, we believe that the current laws, regulations, and practices are sufficient to ensure municipal officials to do violate Wyoming statutes or Constitution. We do not need to deputize the Wyoming legislature for this task. Thank you for the opportunity to testify on this bill. In closing, the town of Superior is opposed to this as the Wyoming Association of Municipalities. At this time, I'll stand for any questions that you may have, but those are kind of my thoughts. Thank you.
Questions? Well, thank you for testifying.
Thank you for your service.
Any more?
I'm admitting Matt Murdock for second testimony.
Mr. Chairman, I appreciate your willingness to let me speak again. I wanted to specifically address the comments by Mr. Dow, and the way the bill is currently structured, there is actually a final and immediate actionable item of withholding funds from a municipality if he judges there's a violation, and there is no means to appeal that. There's a direct order by the Attorney General to the state treasurer. State treasurer must immediately act by withholding the state allocated funds. There isn't really a due process. If the town of Pinedale had its funds withdrawn, I don't know. I mean, we say we should go to court. Mr. Dow's testimony said it doesn't need to go to court to save people money. However, I would argue that as one of 99 towns in the state of Wyoming, if we actually disagreed with the state violation, then there should be some means. And so what this bill does is it immediately takes action and removes that process. So I just wanted to address that. Perhaps Mr. Dow is looking at a bill that was drafted in Arizona and that did not fully carry over into the state of Wyoming. However, upon our reading and my reading of it, there is a direct actionable item here which does concern me, and not only separation of power, but also due process. Thank you, Mr. Chairman.
Mr. Chairman, can we hold this over till the next meeting?
Just getting ready to say that.
Yeah, because we have third
I'm gonna
reading.
put a motion out.
I would move to table it till the next meeting.
Second?
All in favor?
Aye.
Aye.
This Revenue Committee meeting is now adjourned.